Probably, madam, we can start.
Yes.
So, good afternoon, everyone. We are heading towards the second technical session. Uh,
Sir, participation is very less actually. Can we wait for another 2-3 minutes so that
As you said.
Okay. Just 1 or 2 minutes we can wait.
Yes, yes, yes.
shall we wait? We can. Okay. So, good afternoon, everyone. This is the second technical session of the National Workshop on Alternative Dispute Resolution. I so uh, we are honored and privileged to have our resource person, assistant professor, Mesh Krishna Arjun Badade, assistant professor, Marathwada Mitramandal Sankar Rao, Shavan Law College, Pune. I request our coordinator, assistant professor, Mr. Chittaranjan Gogoi sir, to once again introduce our resource person, madam. Krishna madam, please Gogoi sir.
Thank you, Lupta sir. Thank you for giving me this opportunity to once again introduce our resource person. I think some of the participants have joined lately, so it will be better to introduce Madam in this session. I will just quickly introduce our resource person, Madam Krishna Arjun Badade. She is working as assistant professor in Marathwada Mitra Mandal's Sankar Rao Chavan Law College, Pune. She completed her graduation and post-graduation from Savitribai Phule Pune University, and she is currently pursuing her PhD degree from Gondwana University, Maharashtra, and she is a member of IUCN Commission of World Environmental Law, Communication and Education, WIPO ADR Young Forum, and she has presented papers in various national and international conferences. and published many articles, book chapters. She has also edited one book on transforming dimensions of IPR, problems and prospects of information age. She has delivered many talks in conferences and workshops, and she is currently serving as the coordinator IQAC, IPR Cell, Family Counseling Center, and Center for Advanced Legal Research and Training at Marathwada Mitra Mandal's Shankar Rao Chavan Law College. Madam is keenly, she's interested in ADR issues, so we have invited her for delivering a lecture on this national virtual workshop on ADR issues. So thank you, madam, for accepting our invitation and joining this workshop. Thank you very much. Over to you, madam. You can start with your session. Our participants already have joined. 53 participants are there. 54 participants are there. You can start, madam.
Thank you so much, sir, for a generous introduction given by your Gogoi, sir. Thank you so much, sir. And thank you all the dignitaries who are present over here and my dear all participants. So the topic which I am talking about is contemporary issues and challenges in an arbitration. So shall I share my screen?
Yes, ma'am.
Just a minute. I hope the screen is visible to all of you.
Yes, ma'am.
Thank you so much. So the topic which I am discussing with you all, that is the contemporary issues and challenges in arbitration. The earlier speaker might have given you idea about the arbitration. What is arbitration? What are all those advantages of the arbitration? And might be he has given you idea about the law which we have in India and how we are dealing with the arbitration proceedings and some of the judicial precedents as well. But still, we are having a certain kind of issues and the challenges at the national as well as the international level. And today in this session, we will be discussing about all of those particular issues and the challenges. And probably we are providing certain sort of solutions so that we will be having an effective arbitration. And then we can say that we will resolve whatever may be the disputes which are there through the arbitration. Now, if you see, I have quoted over here one of the quote of Abraham Lincoln, who said that discourage litigation, persuade your neighbors to compromise whenever you can, point out to them how the nominal winner is often a real loser in fees, expenses, and a waste of time. As a peacemaker, the lawyer has a superior opportunity of being good man. There will still be business enough. What does it means? That the Abraham Lincoln is not saying that you cannot go into the court of law. But whenever you can do a compromises, whenever you can use your skills, and whenever you can resolve that particular dispute through the amicable settlement, that we will have to focus upon that, and then we will have to consider that particular thing, and we will have to go for a ADR. Now, he also said that many a times we have seen that nominal winner, he considered him as a nominal winner, whosoever is saying that I am winning this particular case, right? So he says that many a time it have been seen that the person who has win that particular case, that he is not considered as a winner. Sometimes he can considered as a real loser as well. Why? Because maybe he has given a lot of fee to the lawyers. Maybe he has done a lot of expenses over there, and of course, the wastage of time, because he has gone into the court, have wasted a lot of years over there, especially with reference to the civil suits, right? So might not be consider him as a real winner. Might be he will be a real loser. So as a lawyer, what we need to do, that as a lawyer we have to find out that what all those opportunities which are there, where we can do the compromises, where both of the parties can win certain things. And of course, whenever we are thinking about the amicable settlement, so there will be a benefit of both of the parties. So this is a very good quote which has been quoted by the Abraham Lincoln. Now I will be just sharing with you the details that how much pendency we are having of cases in India. India is considered as the largest number of pendency of cases in the world. If you see, I have mentioned over here the data which has been published by the Supreme Court of India. And of course, our the then law minister who has given us the information in the month of February 2023, that how much cases which are pending in India. So if you see that he has quoted over there that more than 4.32 crore cases we are having a backlog of those particular cases in the courts, including the high courts, the subordinate courts, and the Supreme Court. Out of those particular backlog, only what we can say that the 70, near about a 70,000 matters which are pending before the court. And this is the data which I have taken from the Supreme Court's website. And it was the data which was published on the day, that is 1st of September 2023. So you can see that this is a recent data where we are having a pendency of the matters only in a Supreme Court, that is 69,506 cases, right? So this is a big number, those matters which are pending before the Supreme Court, and forget about the subordinate court and the High Court. So we are having a lot of backlog of cases entire or throughout in India. And especially that law minister have stated over there that backlog more than 59 lakh cases in a countries across the 25 high courts are there. So this is a big number. And if we are going into the courts, if we are saying that no, I have to go into the court, I have to seek a remedy from the court, so it won't be possible, right? And whenever the justice will be given, I think the earlier speaker has quoted one more quote over there, that justice delayed is justice denied. And there is one more quote which is there, that justice hurried is a justice buried, right? So we have to think from both the perspective, and then we have to consider that ADR is an effective kind of a mechanism where we can go and where we can seek the remedy from those particular ADR systems. Now, as far as concerned with the ADR mechanism, earlier speaker might have given you idea about the types of the ADR. I will just quickly go through all of those particular forms of the ADR or the types of the ADR, and then we can more focus on the arbitration. Intentionally, I have made this particular slide so as to understand that what are those forms of the ADR which are available. I have made two columns over there. The left hand side column is talking about the five kinds of the mechanism which we have in India, that is arbitration, mediation, negotiation, conciliation, and lok adalat. And these are the certain kind of forms for which we can consider it as an unconventional form, or nowadays a lot of people they are going for those particular types of the ADR as well. So what is arbitration? So arbitration is a kind of a mechanism where you are appointing a person who is an arbitrator, who is a skilled person basically, and whatever the decision which is given by the arbitrator or a panel of the arbitrator, that is binding upon the party. So this is one kind of a feature which has been given with respect to the arbitration. And we have a settled law as far as concerned with the arbitration and the conciliation, that is Arbitration and Conciliation Act 1996. Now, the second type of the ADR mechanism which is there, that is a mediation. So in this type of a ADR, the parties they themselves are appointing a mediator who is considered to be as a third party, who is basically assisting to the party to come up with the solution. And whatever the opinion which has been formed by the mediator, that is not binding upon the party. Now, the third type of the ADR which is there, that is a negotiation, where there is no interference of the third party. The parties who are having a dispute among themselves, they are coming up together and they are resolving their dispute by their own. So again, it is a unique kind of a form of the ADR which is there. Then the fourth one is a conciliation, where the neutral third party which has been appointed by the parties, and uh, the particular conciliator is giving us suggestions over there, and accordingly they can come up with the solution. So again, we are having basically the law with respect to it, that is Arbitration and Conciliation Act. And the last one is a Lok Adalat. So whatever the cases which are pending before the court, or where there is a possibility that the compromises can be done, so certain type of cases can be referred to the Lok Adalat. And of course, the parties, they are also having a choice to go for a Lok Adalat. So this is again the unique kind of the form which we have in India. And of course, this kind of a form which is there, might be you have heard about the panchayat system, right? The village panchayat was there. So it is moreover based on that particular concept. And these are the 5 types of the ADR mechanism which we have in India. Those are considered to be as a settled kind of the form of the ADR. Now, these are the unconventional form of the ADR. First is about a mediation and arbitration, that combination of those kind of the ADR. We are considering it as a mid-up. So many parties, they are writing nowadays a kind of the clause, mid-up clause, that firstly we will be going for a mediation, and if that mediation will not be effective one, so accordingly we will be going for a arbitration in a second phase. And that particular award which is passed by the mediator, after that we will be calling him as an arbitrator, because in the second phase he will be considered as an arbitrator, right? So that particular award will be binding on the parties. So they are writing that particular clause in such a way that there will be the combination of a mediation and the arbitration. So that is the unique kind of a combination which we are having nowadays. Now, one more type of the unconventional form of the ADR which is there, that is a mini trial. Might be you're thinking that that we have a court trials, right? So why there is a necessity to have the mini trial? In India, we are not very much popular with the mini trial, but in foreign countries, they have certain kind of a mini trials, where you are appointing one person. That person can be considered as a judge. He's a private judge, and he will be looking at to your dispute, and he will be giving a judgment. That judgment is binding upon the party. So that is a kind of a unique, what we can say, that the type of the ADR mechanism which is there. Again, one more type of the unconventional form of the ADR which is there, for which we can consider it as a medola. So medola is again a rare combination, where the party fails to reach at any amicable settlement by way of a mediation. Then this process of a medulla is coming into the picture. So in this method, what they are doing basically, they are again appointing an arbitrator, and that arbitrator will be taking up all of those particular things, will be considering the whatever may be the disputes and the evidences or the documents which has been provided over there, and he will be giving a decision. The difference between the made-up and the medulla is that maybe in a made-up, the person who is a mediator will be considered as an arbitrator later on. In a medulla, the arbitrator is a different person, who is a skilled person, who will be looking at to the dispute in a different perspective, and accordingly he will be giving his neutral opinion. So that is the kind of uniqueness which is there in the mid-up and the medulla. So I hope everyone has understood this particular form of the areas which we have in India as well as in the foreign country. Now, why I have mentioned all of those particular forms which are there, which we are not now using in India, or those are not much popular in India, because we are talking about the contemporary issues and the challenges. So it is very much necessary to understand that there is no jurisdictional bar, as the technology has given us the opportunity. For example, right now I am sitting in a Pune and you all are sitting maybe from a different parts of India or from Orissa, and we are talking to each other, we are interacting to each other, right? So in a same way, that amicable settlement can also be done, right? So here we need to consider that particular thing, and we need to understand that what is going on, or what all those particular forms which are there in a foreign countries as well. So this is the thing which I have included over here in this slide. Now, coming towards the next and a very important kind of a thing, that what all those advantages of the arbitration might be, the earlier speaker has already given you idea that when you're going for an area, so what all those advantages which are there. So the very first advantage is a flexibility. Whenever you are drafting the arbitration clause or an arbitration agreement, the parties who are maybe having a dispute right now, or they are talking about a future dispute, so they have the flexibility to write down that particular clause in their own way. So might be you have seen that a lot of clauses which are different from each other. For example, in Maharashtra, there is a clause which we are writing that whenever there will be a dispute in future with respect to certain kind of a main agreement, then this matter will be resolved by way of the arbitration, and that arbitration will take place in so and so city, and the arbitration and the conciliation act will be applicable. Or for example, might be in some other part they are writing over there that who will be considered as an arbitrator whenever there will be a dispute, and how that particular arbitration will take place whatsoever. So according to their need, you can draft that particular arbitration clause. An arbitration clause can also be considered as an arbitration agreement under section 7, right? Or you can make a separate arbitration agreement as well. So there is a flexibility. So who can be the arbitrator, where that arbitration will take place, so on and so forth. So there is a much flexibility which has been given on the part of the parties. The second feature which is there, that is a neutrality. When we are talking about a neutrality, so there is a one of the most important feature which have been enumerated by way of the provisions in the arbitration and the conciliation act. So if you see that section 12 which is there, so section 12 which talks about the disclosure by the prospective arbitrator. So whenever you have an idea that you now being appointed as an arbitrator, so you need to discuss each and everything with your parties, that whether you are having an interest in the subject matter, whether there is any chances of a biasness, and then the parties can decide that whether they want you as an arbitrator or not. So neutrality shall be maintained. So neutral person can be considered as an arbitrator, right? Then the third one is a time and efficiency. Of course, if you're going into the court and if you're going for a ADR, there is a difference in time and efficiency as well. For example, in case of the civil matters, so you need to go there, you need to follow the procedure which has been given under the CPCO. So it takes a lot of time. And just now we have seen that the data of a pendency. So it takes a lot of time over there. Whereas if you compare with it, so whenever you are going for an arbitration, so there is a less time which you are taking. And of course, in case of an ad hoc arbitration, where the parties are having a choice to appoint an arbitrator, so they can decide the arbitrator and they can decide the time limit as well. There is one more provision which has been given under the Arbitration and the Conciliation Act, that is section 29B, which is an amended section, which talks about a fast track arbitration. So you can write down in your arbitration clause or an arbitration agreement that our arbitration will be fast track arbitration, so that the entire proceeding has to be done within 6 months, right? So again, that is the time limit which has been given over there, and it will not be a wastage of time like the court. Now, party autonomy. So just now we have discussed that the parties are having a choice to appoint an arbitrator, the place of the arbitration, then the proceeding, how the proceeding will take place. Each and everything will be decided by the party. They have their own choice. So this is a kind of advantage which has been given in an arbitration. Then the confidentiality, as far as concerned or compare with the court proceeding, there is a much confidentiality in an arbitration matter, especially when we are talking about an ad hoc arbitration. So you are appointing the arbitrator, you are discussing whatever may be the issue before the panel of the arbitrator or the arbitrator, and accordingly you are maintaining the confidentiality as well. In a civil suit or in a court proceeding, it might not be, right? Because whatever the things which has been disclosed over here, so for example, if you go to the e-courts website, so you will be getting a lot of material over there or a lot of information over there. If you just put over there the case number, if you just put over the name of the parties, right? So here the confidentiality has been considered, and whatever may be the dispute, you can discuss with the panel of the arbitrator, right? Accordingly you can take the award from there, right? Now, what are those challenges or the issues in an arbitration? The first and the foremost thing, as far as concerned with the domestic arbitration, is a conventional thinking. Now, what do you mean by conventional thinking? That a lot of people still in India, they are thinking that ADR mechanism is not that much effective, and basically there is a kind of a fear in their mind that if we go to the ADR mechanism, might not be the fruitful thing, and again we'll have to go into the court proceedings. So that is a kind of a thinking which is there, and therefore they are not going for a ADR mechanism. One more thing which is very, very much important, that is a lack of awareness. They don't have the knowledge with respect to it, and therefore they do not want to go for a arbitration. Rather than the arbitration, we can say that for a ADR mechanism. And here, the NALSA and the other authorities, that National Legal Services Authority and the State Legal Services Authorities and the other NGOs or the authorities which has been established under the Legal Services Authorities Act, they are doing a lot of work over here. Even a lot of NGOs who are doing the work in the ADR mechanism, that if you go for a ADR mechanism, these are the benefits. So people, they don't know about such kind of a benefits which are there, and that is why they are not approaching towards the arbitration. One more thing which is there, that they do not know about a kind of a mechanism which we have developed in India, that is a ad hoc arbitration. They're just thinking that institutional arbitration which is there. Now, what is institutional arbitration? I would like to bring your attention over here that there are certain type of the arbitrations. For example, one is the ad hoc arbitration. Ad hoc, the name itself says that the temporary kind of arbitration which is there. So parties, they themselves have to decide that whether they are going for an ad hoc arbitration or not. So, for example, if the parties, they have decided that we will be going for an ad hoc arbitration, the autonomy which has been given to the parties, that they can appoint their own arbitrator, whosoever, whether that is a skilled person, whether that is the person who is having a knowledge or not. So total, what we can say, that the autonomy or total kind of a flexibility which is there, and accordingly they can sort that particular matter. Even the parties can appoint a sole arbitrator as well, right? Now, the kind of the second type of the arbitration which has been provided over here, that is the institutional arbitration. And if you see that many institutional arbitrations who are there, who are working in this area, for example, the famous examples in India, that is Delhi Arbitration Center is there, or a Mumbai Arbitration Center which is there. Or if you have seen that there is a famous institutional arbitration, there is IIAM, that Indian Institute of Arbitration and Mediation, which is situated in Kochi, which is also providing a certain sort of a training to the lawyers, which is very, very much necessary nowadays if they are going to resolve the dispute by way of an arbitration, they have certain sort of skills, and those skills which have been taught over there. So this is the institutional arbitration. And if you go over there, if you just take the website of all of those institutional arbitrations, so they have the kind of a mechanism where the party is not having a autonomy, that they have established their own rules and the regulations. Whenever you are submitting your dispute to them, so you will have to follow the procedure which they have defined. There is a standard form of a contract, basically, the kind of agreement which you need to sign over there, and you will not be able to appoint the arbitrator. Basically, they are appointing the arbitrator for you from the panel of the arbitrator, right? And they have defined their own procedure, they have defined their own fee, how to pay that particular fee, everything which was given on their website, or everything which was given on their particular agreement. So they are thinking that this is not the our cup of tea, right? We cannot do the arbitration because if you see their fees, so fee is very, very much high, and only the companies they are approaching to those particular institutional arbitration. So if there is a matter between the individual and the individual, might not be the fruitful thing when you're going for an institutional arbitration. So that is a kind of a lack of awareness which is there, and thereby the people, they are not going for the arbitration. Then one more thing which I have already covered somehow in the discussion, that is sometimes it can be costly and sometimes it can have the undue delay as well. Now, a costly part which I have covered just now, that if you're going for an institutional arbitration, so might be it will take a lot of cost over there. Might be you will have to pay a huge fee over there. The reason behind that, they are providing you the facilities over there. Okay, for example, you can use their infrastructure, you can use their detailed procedure which they have laid down, because many a times it have been seen that whenever you have the autonomy, so you are not coming up with the solution. For example, I will just share one of the example with you so that you can understand this particular thing in a better manner. For example, the parties, they have written an arbitration clause in their main agreement, and they have just written down that whenever there will be a dispute in near future, so we will resolve our dispute by way of an arbitration, and that arbitration will take place in Pune, for example. The place of the arbitration have been written over there, and the rules and the regulations with respect to the arbitration will follow as per the provisions of the Arbitration and the Conciliation Act. So this is just the simple kind of a arbitration clause which you have written over there, right? Now, when the dispute have been arisen, might be there will not be a unanimous opinion between the party that who will be the arbitrator. Now, again, there is a dispute which come up, right? So they need to go to the court. They need to file that particular application under section 11, that please appoint an arbitrator for us. And it will take a lot of time. Of course, you need to pay a fee over there in the court, you need to hire a lawyer, and so on and so forth, right? So, considering all of those particular things, the parties, they themselves have decided that we will be going for an institutional arbitration. They have written in the arbitration clause only that whenever there will be a dispute, our matter will be referred to one of the institute who is working in this field. Maybe that not may be a very famous kind of a institutional arbitration, might be any local kind of a institutional arbitration which is there. For example, in our college also we are having a center for ADR which provides such kind of a facilities. So as compared to the Delhi arbitration center or Mumbai arbitration center, we have a less fee, for example, because Delhi arbitration center and Mumbai arbitration center and the other famous arbitration center, they are dealing with only the companies matter. Companies, they can only afford those particular costs, right? So this is a kind of a lack of awareness which is there, and therefore the people, they are not approaching for the arbitration. So sometimes it may be a costly, sometimes it may have the undue delay. Now, if you see the provisions of the Arbitration and the Conciliation Act, which says that Limitation Act will not be applicable over here. Indian Limitation Act 1963 will not be applicable, and therefore they have given the limitation in the provisions itself, and they have defined over here that you need to wait for certain kind of a period. For example, let us consider for a while award which has been passed, and now you need to go for an enforcement of a award. So you need to wait for at least 30 days, and within that 30 days the other party against of whom that particular award which has been passed can go for a setting aside of an award, right? So certain kind of a thing which has been provided where you will have to wait. Or let us consider for a while that there is one more provision which has been given under the Arbitration and the Conciliation Act, which says that the entire arbitration proceeding has to be done within the 12 months. Because when we are saying that ADR is a very effective kind of a remedy, and especially the arbitration, you need to give a result very quickly, right? So now, considering this particular provision, there are a lot of exception which has been given under the Arbitration and the Conciliation Act. In that provision only, that if you could not finish that particular proceeding within 12 months, then what will happen? Then again you can approach towards the court, and you can take a 6-month exemption. Exemption in the sense that within that particular extended 6 months, you can complete the proceedings and you can come up with the award. Even if you cannot do that particular arbitration within 18 months, again there is one more exception, that you will have to prove before the court that why you cannot finish that particular proceeding within 18 months, and then at the discretion of the court, again that particular period can be extended. So there is a kind of a delay over there. And one more thing which is there, this is only about the act which is saying, and which caused basically the delay. But apart from that, there are many reasons with respect to the undue delay. For example, that if the institution is overloaded with a lot of cases. For example, there are many institutions who are having a workload, over workload, we can say that because of that, they cannot take a hearing, what we can say that the weekly, because arbitrators, they are too much busy. If you see that there is a lot of scope with respect to the arbitrators nowadays, right? They are earning a lot because they don't have a time, especially on Saturday and Sunday, because a lot of individuals and the companies, they do not find the time on weekdays. So if you see their schedule, it is so much busy, right? So considering that particular aspect, the arbitration process will takes a lot of time, or it takes a lot of time, and there is an undue delay as well. Now, one more challenge which I have find out many a times when I am drafting the arbitration agreements. Uh, Basically, there is a problem in the construction of an effective arbitration clause. For example, I believe that if you are, as a lawyer, if you are writing a kind of a clear clauses in any of the agreement, then might be there will not be a dispute in future, that I believe. So basically, if you see that lot of lawyers, what they are doing, they are writing a clauses which is very vague or which is very ambiguous. So that should not be done. Might be it will lead to the another kind of a dispute, and that is a kind of a challenge, or that is a kind of a issue which we are facing in arbitration, that the people, they are taking a benefit of such kind of a vague clause. For example, I'll just state one of the example over here so that you can understand that in one of the arbitration clause you have written over there that whenever there will be a dispute in future, the dispute will be resolved by way of arbitration. Arbitration will take place in Pune. We can take a arbitration proceeding either in English or in Hindi, and the provisions of the Arbitration and the Conciliation Act will be applicable. For example, so now you have written two languages over here, or English or Hindi. Now, if you write over there that the language will be decided by the parties whenever there will be a dispute in future. So might be that was the clear clause, or might be if you have written over there that we will be using a English language for filing purpose, and for a argument purpose we can use the Hindi with the mutual understanding between the parties, because I believe that when you are making a agreement, at that time the parties, they are understanding the importance of the terms and the conditions which we are writing in an agreement. But later on when there is a dispute, so they do not want to understand, basically that is the problem, right? So you have written a kind of a vague clause over there, that where you can use either this language or that language. Maybe there will be a dispute in future, that one is saying that I want an English language and the other one is saying I want only Hindi language. There is no issue when two of them are saying that okay, we can use both the language, and other is ready to accept the same. But one is saying that I only want English and the other one is saying that I only want Hindi, then there is a problem, right? So construction of a arbitration clause is a very, very important thing. So that particular clause should not be very vague or ambiguous. Then the next one is a fixing and deciding the remuneration. So again, here is the big problem, because the parties have the autonomy, especially in the ad hoc arbitration and in the international commercial arbitration as well. They can decide whatever may be the remuneration. So if you are not writing certain kind of things into your arbitration clause, might be it will be a very big challenge for the arbitral tribunal later on. Okay, so you will have to decide that who will be paying, when will be paying, and in what mode you are going to pay. So that is the big thing which you need to understand at the time of making the separate arbitration agreement or a arbitration clause whatsoever. Then I believe that the next kind of a challenge which is there, that is many a times I have seen that the parties are not cooperating with each other. So just now I have shared a lot of examples with you, that when there is an arbitration clause, there is no separate and supplementary arbitration agreement which is there. And the parties, they do not understand that if we come up to this particular ADR mechanism, if we want to have the amicable settlement, so there is a essential elements which needs to have in between ourselves, that is a cooperation. So they are not cooperating basically to each one of them, and that is why the arbitration it will not be a fruitful kind of arbitration. So that is kind of an issue which is there in the arbitration. Then selection and the composition of the arbitral tribunal. If you have not decided by way of an arbitration agreement, so it becomes a very difficult later on when there is a dispute, that you are going to appoint the arbitrators over there, right? We have one provision in our law, that is the Arbitration Conciliation Act, that the odd numbers arbitrator have to be appointed. You can appoint a sole arbitrator as well, but if you are going to appoint a number of the arbitrator, more than one, so you need to appoint the odd number of the arbitrators. So now, for example, if one of the party who is saying that I want this particular person as an arbitrator, and the other person or the other party who is saying that I want this person as an arbitrator. So there is a provision in the Arbitration and the Conciliation Act that both of them can appoint a presiding arbitrator, and three of them will be deciding a dispute. But a lot of time we have seen that those arbitrators who have been appointed by the parties, they are having a certain sort of a biases, and therefore they are not having a unanimous opinion on a presiding arbitrator. So that is a big challenge again before the arbitration. Then lack of administrative support, especially this is a kind of an issue when you are going for an ad hoc kind of arbitration. You are not having an administrative support because you have decided that this person will be acting as an arbitrator, and you will be resolving the dispute by taking his help. So you will have to decide a place, maybe on that particular place there will not be any administrative kind of a support you will be getting. So there is a lack of administrative support as well. Now, one more thing which is there, that there is a shortage of a quality of an arbitrator, the depth of the quality of arbitrator. So if you see that a lot of persons who are not having a skills or the knowledge or the certain other things which are required in an arbitration, the very and the foremost thing which you need to have, that you should have a listening capacity when you are doing a arbitration matters. And if you see that there are only few lawyers or few arbitrators who are there who are having this particular quality, or let us consider for a while that the parties, they do not have any option, so they are appointing a person who is not having a knowledge with respect to that particular thing. Especially if you see that a lot of persons who have been appointed nowadays who are having a knowledge with respect to the laws, but you will have to consider the person who is having a knowledge with respect to the finance when there is a financial dispute, right? So we will have to consider all of those particular things. And quality arbitrators which are not there, if you see the various kinds of the institutions who are giving a recognition, accreditation, especially the IIM, which is the topmost kind of the institutional arbitration, and giving a recognition to the arbitrators that they are considered to be as an accredited arbitrator. So if you want an accreditation from the IIM, you will have to go there, you will have to take a sort of a training over there, you will have to do all of those particular assessment, and the evaluation will be done, and accordingly you will be getting that particular certificate that you now been accredited as an arbitrator. So there are very less arbitrators who are there who are having accreditation, or at the international level there is a APCAM, Asia Pacific Arbitration and Mediation Center, again, which is a very kind of a famous institutional arbitration which is there. So you need to take a accreditation from there, and then only you can do the practice with them, right? So there is a kind of the what we can say, that the shortage over there with respect to the quality of the arbitrators. Now one more thing which is there, that, okay, just a minute, that there is a what we can say that just a minute, I think, is it visible to all of you? Can anyone respond?
Yes, ma'am.
Yes,
Yes,
ma'am.
ma'am.
So the last one which I am talking about it, that there is a myriad of the arbitral institution. That there are a lot of arbitral institutions who are providing the facilities for you. But if you see that those kind of the institutions, they have their own setup. So ultimately what they are doing, that they are having their own rules and the regulations which they have framed, right? And they have their own policy to take the evidences, either the documentary evidences or the oral evidences. And over there, if you see their rules and the regulations, so it is moreover they have inserted all of those provisions which are there in the Indian Evidence Act. So when our law, that is Arbitration and the Conciliation Act, says that you can't consider the procedural laws. Procedural laws are not applicable, especially with reference to the arbitration and the conciliation. So they are indirectly forcing the parties to come up with those particular evidences, and taking of those evidences is a big challenge for them. So again they are making a request to the court, so court is already overburdened and they are making an application over there. So this is a kind of a irony which is there when we are thinking, when we are saying that we want a arbitration in a very effective way, and there should not be the intervention of the court. So you are again making an application to the court that please give us the assistance in taking off those particular evidences and all of those particular things. So this is a kind of a big challenge in an arbitration field. So those are the challenges which are faced in arbitration. Now I have mentioned the challenges which posed by the technology in a different slide, so as to understand that lot of people they are saying that we have the benefit of a technology, right? And especially if you have seen that in a COVID-19, all of us have taken a benefit of a technology. So arbitration is not the exception. Arbitration has also taken certain kind of advantages of a technology. So a lot of the arbitration proceeding which has been done virtually by way of a video conferencing. And they have tried to understand that what is the dispute, and accordingly they have given an award as well. So they have considered the soft copies over there. They have considered what we can say that the lot of things which are available in an online mode by way of taking the advantage of the internet and all of those particular things. But at the same time, we will have to look into that what all those disadvantages which are there when we are using a technology, especially when we are talking about a ODR mechanism, that online dispute resolution mechanism, and especially the virtual kind of arbitration. So the very first thing, that ensuring the security is a big challenge for us. Now, when we are talking about ensuring security, reliability, and privacy issues, the first and foremost thing which we need to understand, at least in India, that in India there are still certain villages, or there is a certain kind of a geographical locations where we are not getting the internet connection. So there is a very poor condition which we are having in India. So it won't be possible 100% that we are taking an online kind of a arbitration over here in India. But we will look at from the international perspective, right? We will just imagine for a while that we have a very good internet connectivity and we are taking a benefit of it. But then also we'll have to think that what all those challenges which are there. So the very first challenge is ensuring security. Now let us consider for a while that we have heard many a times that every kind of search engines companies, they are working on certain kind of policies. Let us consider for a while, whenever we want to know anything, so we are just Google it, right? How the Google is working, have you just understood all of those particular things? So Google is basically providing the information which is available over there, and of course you just think twice. You can see after this lecture, you can just take a demo over there. Day before yesterday, I'm just typing mail, okay, and I have written over there in the mail that the file which was attached to the earlier mail, kindly refer that particular file and revert back to me. So for example, I have written such kind of a mail over there, okay. So the Gmail system was saying to me that you were saying that the file attached, but here is not the file which is attached. So kindly see and then send the message. So before sending, this message is pop up over there in the Gmail, right? So you can see over there, nothing is keep it secret when we are using the internet. So what about the security? We don't know about it, right? Because we have seen many times that the government websites are hacked. Okay. So forget about the private individuals' data. So we need to have the stronger mechanism to protect a kind of a privacy, protect the kind of a security over there. Security should be there. So as to the persons, they can make they can ensure that the confidentiality will be there. Because when you are sharing the data with some other person, so tomorrow the data will not belong to you. That is the kind of a mechanism which is there on the internet. So for example, if I am sharing any of the document, so I'm not giving any kind of assurance that the other person will not be leaking this particular information later on. And when it comes to the companies, when it comes to the private individuals, those who are having an agreement, might be they are having a certain sort of individual kind of a disputes which they wanted to resolve by way of arbitration. So when we are saying that there is an advantage of arbitration, that arbitration makes or ensures that the confidentiality will be maintained. So now here there is a big challenge that whether we are ensuring that particular confidentiality, whether we are ensuring that someone who is not hacking your PC or the device through which you are taking a video conferencing, or whatever may be the mails, or so on and so forth. So this is a kind of a thing which we need to understand. One more thing is there, that when we are sharing certain sort of evidences before the arbitral tribunal, so again there is a threat to those particular documents as well, because if you are not having enough security over there, might be it will be the possibility that those documents will leak, and thereby the company will be at a loss. So again, this is a kind of a challenge which posed by the technology for us. Again, the reliability. Many a times we have seen that the person, many persons, they are doing that they are using our name, they are joining the meetings. We have seen a lot of time in a COVID-19, right, that somebody who is using the name on a certain platform and attending that particular meeting, but we don't know that whether that particular person is really attending the meeting or not, because many a times now also I can see over here that very few people, they have opened their camera, right? So this is a kind of a big challenge where we can rely upon certain things or not. So this is a kind of a big challenge when we are considering the arbitration, and of course the privacy related issues. So this is a big kind of a challenge before the technology, not only as far as concerned with the arbitration, but overall it is a kind of a issue which we are facing, uh, which has been posed by the technology. Now, what are those possible solutions? Because I think my time is running out of it, and I have only 4 minutes. So I'll try to finish up with giving the possible solutions over there. I have not inserted all of those particular possible solutions over there, but those which are important one, those on which we can work on. So that thing we can consider over here that I have inserted in the slide. So the very first thing which we can do, that we can create a awareness. And how we can create a awareness, unless and until we understand the arbitration proceeding, we will not be able to create a awareness over there. So first we will have to start from ourselves. We try to understand that what is arbitration, what are those benefits, and how we can go ahead with the effective kind of arbitration, and how that particular arbitration will not lead again to the possible kind of the litigation, because many a times we have seen that the award which has been given, which is not enforced, again the person who has filed a application for setting aside, and during the arbitral proceeding the persons, they are filing the applications in the court lot of time. So simultaneously arbitration is also going on, certain applications which are also going on, so there is no meaning to it, right? So we will have to make a different kind of a picture over there, that we are going only for a arbitration, and we will be having an effective kind of a arbitration. So when it will be possible, when the people, they are aware about such kind of a thing, we will have to set up their mind basically, right? So this is the kind of a possible solution where we can have the effective kind of a arbitration. Secondly, adopt the client mindset. First of all, we need to understand that what is the mindset of a client. Okay. Many times we have seen that, because if you are going for a mediation or a conciliation or a negotiation, the clients have their own understanding that we want a compromise. Okay. Especially with reference to the mediation, when there is a win-win situation. Okay. There are four issues and the party is ready to compromise on a certain issues. For example, two issues can be resolved in my favor, so I need to give up for two issues. Okay. So he is ready for that particular thing. But as far as concerned with the arbitration, many a times we have seen that the client is, one of the client is not ready to come up with the compromise. So we need to understand that particular mindset first as an arbitrator, as in the part of that particular arbitral tribunal, or the concerned person, and we need to understand their mindset, and we need to groom them that if you are going for an arbitration, this would happen. So you need to imbibe whatever may be the advantages which are there of arbitration. And we need to understand, first of all, and let them make understand that this is a kind of a thing which is very beneficial for you. Otherwise, it will be a wastage of time. So adopt that client's mindset over there. Then the third one is a very, very important. That is a increase the efficiency. Lot of time we have seen that the arbitrator are for the namesake only. Okay, they're not looking to that particular dispute in a neutral way, in an independent way, and they're just giving the award. That award is also not proper one, and accordingly the parties they are going before the court challenging that particular award, so on and so forth. So efficiency, effective kind of a award which we need to give over there. So we need to increase the efficiency. So there are a lot of things which we can discuss under that particular efficiency. So we need to draft that particular arbitration clause in an effective way. We need to understand the mindset of the client before the dispute, or might be after the dispute when they are making a separate arbitration agreement. We can write down certain things over there in a detailed way, and maybe we can have that particular thing in our mind, so that in future whatever may be the possible disputes which are there, those should not be done. So you will have to think from that particular perspective, and then you can understand this particular point, that we need to increase our efficiency. We need to look to the dispute from a different perspective. Then last one is utilize the technology for the innovation and not for the automation. Many a times we have seen that nowadays we are using a AI system, right? The technology. So technology is taking care of all of those particular things. We are giving an input, technology, that AI basically is giving the output. And a lot of discussion which is going on, especially Gogoi sir has given an introduction and he said that I am a member of a WIPO area. So a lot of time we have that particular discussion over there, that how we can use the AI, especially in an ADR mechanism. So a lot of the persons, they are saying that we are having a lack of quality arbitrators. So can we use a AI over there? But then we need to understand that there are certain restrictions of the AI as well. You need to give an input over there. The machine will be giving you the output only, but they will not be applying the mind, right? So we need to understand the importance of the technology over here. We need to utilize that technology for a innovation and not for automation. We can use this platform to interact with each other. Maybe we will be having an interaction. You are asking certain sort of queries, I'm giving an answer to those particular queries, and then maybe we can come up with the solution, right? So that is a kind of a thing which we can use. This is an innovative kind of thing. Just think years back, okay, when this technology was not there. So someone who has invented this particular thing, someone who has a mindset, someone who has done this kind of an innovation, and that innovation we are using today. So we will have to think from that perspective, not for the automation, right? So this is the kind of a possible solution. So thank you so much. I think my time is also out, and I hope that this session is not so much boring. Now I can answer your queries if you have any.
Hello, ma'am. Good evening. My name is Shweta,
Yes.
and
Yes,
ma'am,
please.
are you able to see me?
Yes, yes, I can see
Hi.
you as well as I can hear you.
Okay. So I'm from Hyderabad. I study at Mahatma Gandhi Law College. So your session was wonderful. So another thing is, so I was just writing down something, some doubts that I have. So, ma'am, as we know, the legislature, the administration, and the judiciary, they have to work hand in hand for things to be better in our country.
Yes.
So, one main question that I have is, see, our judges, if they stop taking cognizance of very silly matters from the beginning, then we can avoid a lot of cases that's there pending, the pendency of the cases, one thing, what I feel. Another thing is, whenever somebody goes to the police station to file an FIR, why don't we have an arbitration center there itself, where we give more power to the police than right now what they have? What I see is, the judiciary has got all the power in their hand, and even the legislature, but comparatively our administrative structure, where our police is given a lesser power, though we say that they go out of their hand and they do things. But what I feel is, when somebody goes to file an FIR, why don't the police refer it and mention that they have already referred it to an arbitration center, and then the complaints were probably not ready in case they are not ready for going for arbitration. I feel they should mention that along with the charge sheet when they file it in the court, so that the judge knows that, okay, this case was something which was already meant to be compromised, it was tried by the police, and still the litigants have said no. Now again, the judge can take cognizance of this matter and go ahead with it and say that even he believes that this can be going to an arbitration center. And if the clients or the litigants are still not okay with it, then it's okay, it can go to the next step. So I feel we should nip it in the bud, from the bud, from the police station itself, so that we have lesser pendency of cases. It's just my opinion.
Okay, I
Please.
would like to add some more things. I mean, whatever the suggestion which you have given, that was absolutely very good suggestions. I would like to add some more things into that. That instead of arbitration center, we can have a kind of a mediator over there in the police station, and in Maharashtra especially, we have that kind of a system
Absolutely.
over there. uh, we are saying to them as a police mitra, okay, so who is a friend of a police. So whenever there is a petty kind of a disputes with, for example, the kind of a dispute between the husband and the wife, and wife wanted to file the FIR against of the husband. So basically, they are referring such kind of a matter to the concerned mediator, that police mitra, and he is understanding that what is the case actually, and is it really worth to go into the police station, and is it really worth to going into the court. And accordingly he is giving certain sort of a guidance over there, and half of the matter which has already been sorted out at then and there only. One more thing which I would like to mention over here, that in our the Gogoi sir has also mentioned that I'm a coordinator of a family counseling center. So we are doing that in our family counseling center. So basically, taking into consideration a lot of things, we are doing a counseling, and when there is no possible kind of a compromises which are there, then the matter which we are referring to the court, that now you can go into the court and now you can file that particular case. So that can be done, I think, as a citizen of India, as a responsible citizen of India, and this is our social responsibility, right? So whenever there is a such kind of a dispute which is having, which is not that much really worth in going into the court, we can sort it out outside of the court. So we need to encourage the people to come up with the solution, right? So this kind of a mechanism can be there, so that there will be a less burden on the judiciary. So I agree with that.
Right, ma'am. Thank you so much.
Thank you.
Yeah, ma'am. Good afternoon, ma'am.
Good
This is
afternoon.
This is Shravan Kumar from NSS Law College, Hyderabad. Okay, my query is regards to this foreign or international arbitration cases. Who are the custodian, and if in any case, if they fail to, fulfill the awardees and all those things, who will be the responsible? Because since this is the foreign case, we cannot, rely on the other parties, because this entire transactions is happening on the outside of the country. So that who will take care of this responsibility and all those things?
Okay. So there is a concept of an international commercial arbitration, and our law also deal with certain kind of thing, the definition and the provisions which has been given. So there are two parts basically. So part one is providing the general principles of the arbitration, and part two is about a certain kind of a conventions which talks specifically about the international commercial arbitration. So, in an international commercial arbitration, again, the choice which has been given to the parties they themselves have to decide that which law will be applicable to them. Again, this is a big challenge before the arbitration, because when we have given autonomy, so they are deciding their own law. So, for example, if the party who is from India, one of the party who is from India and the other party who is from other country, and they have decided that the law of India will be applicable to them. So accordingly, the proceeding has to be done, and they need to decide the place of the arbitration as well. And whenever the award will be given, so for a execution of the award, they need to come over here, or through the Indian court only that award needs to be executed. And for example, if they have decided that this particular award needs to be executed over there, the laws of the other country will be coming into the picture. They have decided, they have written in their arbitration agreement, so they need to go over there. So the execution
Yeah.
of the award will be done as per their law.
Absolutely, ma'am. But here the case, these issues are arising once they fail the commitments and all those things, and most of the cases are related to civil matters only. So when these cases probably, I mean, if they fail the commitments or if they fail the
There is a big
contracts and all
challenge
those things only.
actually. There is a big
Yeah.
challenge. And New York Convention and Geneva Convention, which talks about that as well. And of course, many a times we have seen that when the convention and the treaties are applicable, when you have signed those particular convention and you have ratified those, right? And if you have not ratified, if you are not a signatory to that particular convention, it won't be applicable, right? So that is a loophole which is there in the international law. So that is a kind of a thing which is there. And of course, one more thing which is there, that we need to understand the kind of a dispute as well. There are certain kind of the ADR mechanism which has been developed, like you are asking about a custodian or you are asking about an authority at the international level, right?
Yes.
So, especially with reference to the IP matters, WIPO is there, that World Intellectual Property Organization, which is there, and they have their own rules and the regulations, and they are looking into all of those particular matters. So, matters will be resolved by their what we can say that the ADR forum, and if not, they are taking a responsibility of it. But not every matter is being resolved like that. Okay, so that is a big kind of a loophole in the international law.
Yes. Thank you, ma'am.
Excuse me, ma'am.
Madam, this
Hello,
is
ma'am.
Srinivas from Hyderabad. Actually, a JDR, Judicial Dispute Resolutions, if they are biased, what is the solution?
Can you repeat your
They do
question?
not
Because
follow Judicial Dispute Resolution, JDR.
yes, yes.
If there are bias, if it is biased, like Gogoi sir's, uh, whatever the allegations, if they find it biased, is there any remedy?
So, so you are asking about a judicial dispute resolution. So you are talking about the court proceedings, right? When the judge is biased.
Yeah, one of the judicial employee or whatever judicial has any issue in judiciary.
Okay. So ADR and judicial dispute resolution mechanism is different, right? First thing which we need to understand. And a kind of the trust which we have given, or trust which we have developed through various kinds of laws in India on the judiciary. So basically, you cannot take action per se against of the judiciary when you are saying that the judge is biased one. Rather than that, you can make an application to the higher courts. For example, if the case which is going on before the subordinate court, and you think that the judge is biased one who is having an interest in the subject matter, so you can make an application to the high court that please transfer our matter to the another court, that this judge is having a certain sort of a what we can say that the biasness in our case. He knows the parties, or he knows that particular subject matter. So that can be done when the case which is pending before the subordinate court. Okay. Now, one more thing might be happens that the entire case, because it takes a lot of time, we all know that, right? So, if that particular thing which has already been done, the judgment which has already been given, so there is the another thing which you can file into the higher courts, that you can quash that particular decision. You can demand from the court. So you will have to file the writ for that.
Hello,
Good
ma'am.
afternoon. Good
Prakash
afternoon,
Pandal
ma'am.
here from Barampur University. Good afternoon, ma'am.
Good
You
afternoon.
use the term mini trial in your term, and you say that it's not popular in India. It's, ma'am, as similar as our rural social system or tribal system.
Just a
When
minute, Om Prakash. Sorry to disturb you. I cannot
yes,
hear
ma'am.
you properly.
Okay, ma'am. I again repeat my word. You use the term mini trial. Yes,
Mini
ma'am.
trial, yes.
Yes, ma'am. You said that it's not popular in India. And I, I, I was I want to say that it's as similar as the rural social system or the tribal system of judiciary, like any person, or like in panchayat, it's sarpanch or any person.
So that is what
Uh,
I said, that this is a kind of a village panchayat.
yes, yes,
When
yes, ma'am.
we were talking about a lok adalat, mini trial is a kind
Yes,
of a
ma'am.
private person which they are appointing. So we can't say that we can't interconnect with our system, that is a village panchayat, because in a village panchayat, the persons who have been there, who have been appointed, okay, for example, those five panchas were there, who are having a knowledge, who are a senior citizen, or might be different kind of rules which are there in different villages, right? But here the parties themselves are appointing a private judge. So that is a kind of autonomy which has been given in a mini trial, right? In a village panchayat, you don't have that much autonomy. So whatever the panchas, whatever the
So we have
concerned
to pay
persons,
for that. We have to pay for that person or for that judgment.
they have to pay for that person. Whatever the fee of that private judge needs to be paid by the parties. And if you see that in a village panchayat, sometimes in some of the villages, they are not taking any kind of a penny. They are doing that work voluntarily, right? So that is the difference between the our village panchayat and the mini trial.
Good afternoon, ma'am.
Thank
Good
you, ma'am.
afternoon.
Thank
This is Mr. This is Hello. Good afternoon, ma'am.
Good afternoon.
Yeah, this is Mr. Bhumesh from Vinayak Law College, ADR, from Hyderabad. Madam, yeah, if any award is given in a dispute between the two parties, if it is morally and ethically it is wrong, can it be challenged by a third party? In the court.
Kind of a vague question, I would say. The reason behind that section 34, which talks about a setting aside of an award. Okay, there is no word challenge of the award. In a day-to-day life, we are using that particular word. Okay, so under section 34, you can set aside the award, and there are 6 grounds which has been given. So apart from those 6 grounds, you cannot file an application for setting aside of an award. For example, they have given over there that if the thing which has not been provided over there in the arbitration agreement, or an arbitration agreement is not valid per se, the arbitral tribunal doesn't have a power and they go beyond the power if that award is opposed to the public policy. So there are certain 6 grounds which they have given. So on a ethical basis, award cannot be challenged, award cannot be set aside, but we will have to look into the facts and circumstances when you are saying that ethically. So biasness can be there, okay, and biasness can be considered, or it can be correlated to the ethical things, okay, ethics. So if you are saying that the concerned arbitrator has not disclosed that he was having a interest in the subject matter, and accordingly we have find out that, and when the arbitral tribunal has established, so we have taken an objection with respect to it, but then he opposed to do that, and then we didn't have any kind of other possible remedy in our hand, so we waited for award, and now we are challenging this particular award, or we want to set aside that award. So what kind of facts and circumstances we need to understand, but on a ethical basis, we cannot set aside the award. Ethics can be correlated with those particular 6 grounds. And
Okay.
accordingly, we can set aside the award.
Okay. Thank you, ma'am.
Welcome.
So thank you, ma'am, for a very nice, informative, and very interactive presentation.
Thank you, sir.
Now I would request Ms. Vinita Priyadarsini to propose the vote of thanks, as we have come to the end of both the sessions of the workshop. Vinita ma'am, over to you.
Thank you, Lupta sir. A very good afternoon to all the esteemed guests. I'm sorry to see you. Okay. A very good afternoon to our esteemed guests, faculty members, and dear student participants. On the behalf of PG Department of Law, Barampur University, it's my privilege to take this opportunity to propose vote of thanks to all the esteemed guests and faculty members of different law colleges and all the participants of the second technical section of National Workshop on the Alternative Dispute Resolution, organized by our PG Department of Law in association with the Pro Bono Club of our department. It's my privilege to convey our heartily It's my privilege to convey our heartily gratitude and regards to the resource person of second technical section, Ms. Krishna Arjun Badari, the assistant professor, MM Sankarrao Chavanlal College, Pune, for enlightening the second section by imparting the relevant address on contemporary issue and challenges in arbitration. Madam has rightly mentioned balancing between justice delayed and justice denied, and justice hurried and justice buried, to reduce the backlogs in our courts and providing just justice. So she has also focused on the challenges or issues in arbitration and their possible solutions. I'm sure all the participants immensely benefited from this informative lecture. And on the behalf of our participants, I also thank you for the solving those problems. Thank you, Madam, for being with us and imparting such knowledgeable section. Our thanks again goes to Mr. Chittaranjan Gogoi sir and Dr. Luptaratna Patra sir for PG Department of Law for organizing and conducting such wonderful workshop. We hope forwarding in organizing future workshops and such events in our Department of Law in association with this Pro Bono Club. Our deep sense of appreciation and thanks goes to all the esteemed faculty members and different law colleges and student participants for their active participation in both technical sections with great passion and made this workshop successful. Once again, I thank you all being with us in this virtual mode of this workshop. Thank you. Have a nice day ahead. May I request Mr. Gogoi sir to conclude this workshop?
Thank you, madam, for joining us. At least on the virtual platform, you have you have connected with us. We hope to have some sort of physical mode of interaction in the near future. I thank the participants, those who have joined this workshop. I think the first session was also a bit informative, and the second session was also a bit informative and interactive. Participants have definitely got some sort of exposure related to these ADR mechanisms. So we hope to meet you in the next academic interaction. So I informed the participants that within a period of 7 days, we will be giving you the certificates, and the resource persons, they will be also be given a letter of appreciation regarding that. Also within a period of 7 days, we will be informing you, we will be giving you these certificates. So with the permission of the all the participants and madam, we may conclude this session.
Thank you so much, sir, for this opportunity to interact with the students. And
Yes.
I'm very glad. Thank you so
Yes.
much. Have a good day.
Thank you, madam. Thank you, madam.
Okay. Thank you very much.
Okay.
Thank you very much, sir.
Okay.
The meeting is
Thank you,
concluded.
ma'am. Thank you, sir, and thank you all.
Thank you.
Thank
all.
you so much. Thank you. Looking forward to more sessions like these.
Thank you.
Love from Hyderabad. Bye-bye.
Yes.
Thank you.
Thank you so much, ma'am.
Thank you very much, all the participants. We will keep you informing in the WhatsApp group, okay? For regarding the updates.
Sir,
Thank you
shall
very
I
much.
Thank you,
leave?
sir. Thank you.
Thank you
Shall I
so much,
Yes.
sir.
Yes.
Thank you, sir.
Thank you.
Thank you, all of you.
This
Thank you.
interaction for all of you.
So will it be an e-certificate or a physical certificate?
It should be e-certificate.
Okay, thank you.
అంకుల్ దొరకడం అసలు ఎంత అదృష్టం ప్రతిదీ అన్ని ఒక్క షార్ట్లో సింపుల్గా ఎలా చేయాలి ఎస్ ఆర్ నో అన్నది ఎంత పర్ఫెక్ట్గా నేర్పించి చెప్తున్నాను